Good morning and welcome to the Clermont County Board of Commissioners meeting for February 26, 2024. Prior to starting a meeting, we always ask local clergy if they would come and pray for us and for this county. And this morning is no different. Pastor David Tennant is here with Owensville United Methodist Church. Thank you so much for leading us in prayer this morning. And
my pleasure.
The podium is yours.
Thank you. Be in prayer with me. Heavenly Father, we thank you for this day. And much like fall into winter, the season of change and Advent that approaches the birth of Jesus, we are in the season of Lent, which is again a season of change, not only for spring, but as should be for each one of us, a time of change. These 40 days to examine our conscience, examine our behavior, and change as we prepare, in this case, prepare for the death and resurrection of Jesus. Father, for these people and for all of us throughout this day, prepare them for decision making, again, the discernment, the courage, the awareness, and to be open to you and open to the Holy Spirit in whatever you are calling them to do in this meeting this morning, and then for us as well as we go through our day. We ask this in your name. Amen.
Thank you, David.
You're welcome.
Deputy Berger, since you are here today and sporting your uniform, would you lead us in a pledge of allegiance?
Sure. I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. For those of you who noticed, it's always good to have someone here who's serving in uniform from our sheriff's department, especially from our jailhouse. Thanks for being here this morning. Thanks for everything that you do. So we will get started in a call to order this morning at 10 a.m. And prior to that, we are going to have to designate a pro tem secretary, correct? So I need a motion to add the appointment of a clerk pro tem to the regular scheduled agenda.
I'll make the motion.
It's been moved. Second. Roll call.
Commissioner Batchelor?
Yes.
Commissioner Corcoran?
Yes.
Commissioner Painter?
Yes. And then we'll entertain the motion. The Board of Clermont County Commissioners hereby appoints Rebecca Goff, Assistant Clerk, Board of the Clermont County Commissioners, as Clerk Pro Tem for today's regular session of February 26, 2024. Roll call.
Motion.
Motion.
Mm-hmm.
Make the
Second.
motion. I'll make the motion.
I'll second.
Roll call.
Already
Commissioner
keeping us in
Corcoran?
line.
Mhm.
Commissioner Corcoran?
Yes.
Commissioner Batchelor?
Yes.
Commissioner Painter?
Yes. Rebecca, thanks for stepping in. Gail is on a scheduled vacation, and we hope she's having a good time.
Sure she is.
You bet. We'll move on to item B, which is the approval of regular session minutes of February 21st, 2024. Board, I know you've had these minutes early, had the opportunity to review them. Do I have a motion to approve?
I'll make the motion.
A second.
It's been moved and second. Any further conversation or discussion? Roll call, Rebecca.
Commissioner Batchelor?
Yes.
Commissioner Corcoran?
Yes.
Commissioner Painter?
Yes. Item C, we have a proclamation for designation of March as Developmental Disabilities Awareness Month in Clermont County. I understand Dan Aki is here to accept this proclamation. Do you have anyone else you'd?
Unfortunately, no.
No?
They don't love us anymore.
No, they do, but I guess something came up, and so you only have one day. So,
Aw.
so I appreciate that.
Developmental Disabilities Awareness Month, March 20, 2024. Whereas the Clermont County community is involved in advocating for programs that promote positive system changes and that allow persons with developmental disabilities to achieve optimum independence and to promote innovative programs and practices that improve the quality of life for these individuals. Whereas the most effective way to increase the awareness is through everyone's active participation in community activities and the openness to learn and acknowledge each individual's contributions. And And whereas we encourage all citizens to support opportunities for people with disabilities that include full access to education, housing, employment, and recreational activities. And whereas the United States no longer estimates the abilities of Americans with disabilities due to the signing of the Americans with Disabilities Act in 1990. And whereas the Clermont County Board of Developmental Disabilities is proud to work with partner agencies to celebrate the success of children and adults in our community who have developmental disabilities. Now, therefore, let it be proclaimed that we, the Clermont County Board of Commissioners, do hereby proclaim the month of March 2024 as Developmental Disabilities Awareness Month in Clermont County, Ohio, and offer full support to efforts that assist people with developmental disabilities to make choices that enable them to live successful lives and realize their potential. And it's signed by all three commissioners, myself, Claire Corcoran, and Bonnie Batchelor. Dan, thank you so much for accepting this proclamation. Thanks so much for heading up the Developmental Disabilities Department here in Clermont County. We really appreciate everything that you do.
Thank
and
you
your
very
staff.
much. Appreciate that
You
so
bet.
much. So,
Thank you.
Thank you.
And the podium's yours.
Oh, thank you. I appreciate that. So, well, as mentioned, I just want to thank the commissioners for this recognition. It means so much. And unfortunately, Mark, who's a person we serve, was not able to make it due to some transportation type things. So I know he's bummed because I know he would like to share kind of how important these services are for him as well. But when I was driving down here, I was thinking about how important this really is, because I just watched a documentary called Unseen. I definitely recommend, if you Google that or take a look at it, it's very powerful. It really, what it talks about is the caretaker role that parents take for serving and working with their children, and all the various needs that they have, and all the different things that they experience. And in a lot of instances, it's a situation for those of us who don't have children or adults with disabilities. It's a situation where those caretaking roles, they can be lifelong, and it can be very, very challenging. And it was very, very powerful. And I think that's why, when we recognize March as Developmental Disabilities Awareness Month, it's so critical for us to be mindful of that, to know within our community, within our state, within our country, all the various needs that families have and all the various challenges. And we've come dramatically far in the last 50 years in terms of all the different 50, 60 years that services that are available. But we do always have to keep working towards helping those with the most need. So very appreciative of the commissioners for this recognition, very appreciative of the opportunity to share this morning. So I would just encourage, think of that. If you know of families in your community, reach out to them, even if it's just, hey, do you need anything? Is there anything, that we can help with? As an organization that supports, we recognize our responsibility and our stewardship with that, but certainly it takes a whole community to be able to do that. So thank you very much for the opportunity this morning. So,
Thank you.
Dan, thanks for being with us. And would you
oh,
take a
sure.
picture with
Yeah.
the
Stay up
commission?
here.
You want to stay
We'll
up there?
stay up behind him here.
It's okay, we can get down there.
Okay.
Come on down.
You know, they'll be able to zoom in. There's any problem.
I know we will, for sure.
3, 2, 1. 3, 2, 1.
Uh-oh.
Very good. All right.
Thanks.
Thanks again.
Thanks.
Yeah, it's
I'll
good to
see
see
you
you.
later.
Yes,
Good
you
to see
will.
you.
Yep, thanks. Yeah, good to see you. So, good to see you. Oh, yeah, absolutely. Yeah. He's always fresh there. So it was awesome. So thanks again. Appreciate it.
Thank you.
We'll move on to item D. This morning, we're going to have a presentation from those representing Neighbors Opposing Pit Expansion, or NOPE, here in Clermont County. NOPE is an organization that started many, many years ago that had to deal with the ADJOURN power plant and still that is continuing. So as Mr. Altman gets started here, I would tell you, by all means, kind of bring us up to date. Although there are many people in this room at our age that remember, there may be many people watching today this presentation later on that have never heard of that organization or understand how it got started. Thank you for being here.
And we're absolutely mindful of that.
Tell people who you are. And
I will indeed. I'm Dave Altman. I've been the lawyer for NOPE since about 1985, give or take, and was, I'll say in a minute a little bit more about that. But with me today is Justin Newman. We are from the firm Altman Newman Company, LPA. And also the chairman of NOPE, Wayne Harris, is here today, and he'll say a few words at the end of what briefing I give you. And then Joan Lori, who's been the treasurer of NOPE for many years, and Greg Lori, both are on the board of NOPE. So that's the contingent we have here today. First of all, we want to thank you, commissioners, for inviting us to explain why the county should be concerned about the Beckjord coal ash pit closure, which is a magic word that you hear tossed around always, that leaves coal ash in contact with water. And keep in mind that phrase, because there's so many technical issues here. The problem is that when water contacts coal ash, it weaponizes that coal ash and becomes a threat to human health, property, and the environment. Now, since 1985, NOPE and with Pierce Township back at that time, joined together and entered into with CG&E, the utility for younger people that used to provide electricity out here at the Beckjord plant. We joined together to do something about the threat of all of the fly ash that was being placed around Pierce Township in particular, but in our whole area of Clermont County. And since then, NOPE has used its resources to try to work with the utilities that manage the fly ash and entered into this 1986 historic fly ash agreement that regulated and set up communications between NOPE, Pierce Township, and the various utilities, ultimately winding up with Duke. And that agreement worked for well over 30 years, even when we had to occasionally enforce it. However, when CLP, which is a company that no doubt you have heard about, took over, that cooperation and that agreement, even though the agreement didn't go away, the CLP's participation in it went away. So what we're here today to tell you about are the current, today, threats from coal ash contamination, and to simplify what is a very complex set of rules and regulations that aren't being followed. Leaving the coal ash in direct contact with water is the one you should remember out of this today, because that is the threat. The federal citizen suit enforcement we're here to tell you about today to eliminate that threat. And finally, the third thing is CLP's claims of secrecy about environmental liability related to those threats. So those are the three components. And you've already got the first slide up in front of you, and you and the viewers can see that. And what I want to, you all of you know, I imagine, about the fly ash pits down on the river. It says Ash Pond A, B isn't labeled, Pond C, and Pond C extension. And a lot of attention, especially in the media, has been properly directed toward the fact that these are online, they leak, and they're on the river, and they migrate to the well field in the direction of the well field, since there's nothing to hold the ash in. Plus, remember what I said about ash in contact with water? In this case, many times of year, the river rises into the ash. It's not just a matter of the ash leaking out. It's a matter of the river coming up and washing out ash. And that water in contact with ash, again, is the phrase that I wanted you to remember. So there's widespread contamination. There's threats of slippage and to your residents that live just downriver from sea extension, and also over to the away from the river from sea and sea extension, inundated homes. This is not NOPE talking. This is the plans, emergency plans of CLP and previously Duke, saying about inundation, slippage, and very real concerns. But that's not the news I want to tell you about today, because I think I know your lawyers know, and I'm sure others know all about A, B, C, and C extension. I want to point you to the stuff in red up there. This is in the middle of all the homes of many NOPE members and others who aren't NOPE members, and I'll show you the pointer here to show you the Gott Dam Complex here. Pile A, Pile B, Pile C, and these other two piles, FA1 and FA2 and FA3, other three piles, FA3. These are online. There's nothing to keep the water out of the fly ash waste. Remember, water, waste, weaponizes problem. The top of the hill has not even been monitored, meaning you don't know what's migrating where other than general science. And even though you in the county have done excellent work with your experts telling you about what's migrating to the well field from these ponds, somewhat understandably, though, I don't think you all realized about these other areas at the top of the hill, which also merit concern. And I don't think that the excellent firm you have has even been tasked with analyzing where this material goes. But I will tell you that if you look at where the Gott Dam area is, complex is down here, you will see there's a tributary to 10 Mile Creek that goes right up against us, right on the border, or as a matter of fact, from information we have, actually through the Gott Dam complex and those others as well. But even if it didn't, even if you didn't have 10 Mile Creek up here labeled, even if you didn't have this tributary, you've got groundwater migrating in all directions from this area. This, believe it or not, it's incredible, has, until we got into this, not been really analyzed as it would have to be under federal law. Now, this is a strange federal law because up until fairly recently, the federal government did not have the authority to enforce its own federal law. If that sounds strange, it is very strange. But guess who did have that authority? Anybody, including citizen groups like NOPE, who did what we did, which is to file a notice under the federal law. And the county or the township could also do this. I'm not saying only NOPE can do it. I'm saying anybody who knows about how the law works. Weirdly, that was the enforcement that we had. Now the federal government is just starting to set up shop and exercise its authority to enforce. And you'll see some of the things they've done in a few minutes at the end of my presentation. So here's what you need to take away. All of this up the hill stuff is in waste. Many thousands of tons is in contact with water. So I'm going to tell you a little bit about the secrecy problem that we also have. But let me tell you first, I've got a very delicate situation. There is, I mean, as a lawyer, it's delicate for me because there is an agreement, an environmental liability transfer agreement between Duke and this CLP company, which, according to publicly available information, bought the contamination and then has the duty of cleaning it up under some terms. So Justin and I have seen this agreement, but it's called an attorney's eyes only agreement, meaning we can't talk about anything in it. And I can't even tell Wayne Harris, the chairman of NOPE, or any member of the board of NOPE, or any members of NOPE, anything about that agreement, because it's only for us to look at. But here's what I can tell you. We all know that Duke transferred liabilities to CLP, it's public, in 2018. CLP is a liability transfer company that specializes in taking on liabilities and has throughout Ohio and throughout the country. And I'm going to go now to a slide. Oh, this is I just want to say, in our enforcement lawsuit that NOPE has, only NOPE, pending against CLP, we talk about the up the hill stuff and the things I just told you. This is an excerpt from our motion for summary judgment. What we're saying is, without any further ado, the federal court, Judge Barrett, can find CLP liable, no further facts are needed based on what we say in this motion, liable under the federal law. Remember that, okay? So now let me go to what Ron Froh, Mr. Froh, said to Pierce Township in a public meeting back in 2019 when he talked about what CLP was going to do. And this agreement called the Environmental Liability Property Transfer and Sale Agreement, this agreement, I don't know that we fully knew about. We certainly hadn't seen at that time because we had to fight to see it even with the restrictions. During the presentation to Pierce, Mr. Froh said he doesn't get paid unless he closes, that word closes, the ponds, meaning A, B, C, and the other ponds, in accordance with Ohio EPA regulations. Now that sounds like a very positive statement, except what he doesn't say is not in accordance with CCR, the federal regulations that are the ones that really protect everybody down there by the river and around the river, all your constituents in that part of Clermont. He didn't say a word about the federal regulations. And I want to just remind you, I think some of you know this, Ohio EPA does not have the authority to regulate coal ash. People think, hey, it's an issue, environment. Of course they do. Completely wrong. Coal ash is exempt as a solid waste, which is the basic kind of waste you can regulate under Ohio law. Federal regulations, called CCR regulations, are much more extensive and specific about what needs to be done. For example, you can't leave waste in contact with water. Remember that theme. So federal regulations are very important. So what the state law says, though, and it sounds good if you don't know what it's really saying, we're going to cap these contaminated areas, okay? Now, I don't know how many of you own a swimming pool, hang out around swimming pools, or been to a swimming pool. But what that's saying in this case is like saying, I'm wearing a big sun hat and I'm going to throw it in the pool, and any rain that won't get through that hat, it won't contaminate anything in the rain, won't contaminate the water underneath. Well, it's a pool. There's water flowing through. No, in that little area where you have the hat or cap, you won't get the rain. But because the water is already flowing through, it doesn't mean anything. That's the difference between the federal regulations. The federal regulations require you to think about the water flowing through. Ohio regulations say, well, put a hat on and you'll limit the amount of water that comes into the waste from the sky. So anyway, that's just to help you understand a little bit. Now, so this all sounds pretty, what's this regulation? You know, how do we really know? You're a lawyer, you represent NOPE. How do we really know this matters? First of all, we spent a lot of time figuring this stuff out, but way more important than that, CLP, unbeknownst to us, asked to talk to the US EPA. And they said, you know, these people from NOPE have sent us a notice, and this notice says we have to comply with the federal rule. And we really don't, but for technical reasons. And then unbeknownst to us also, this letter came out in I guess it was 2023, early 2023. And it says, yes, you do. Because you, CLP, moved waste from Pond A over to Pond C extension, making things worse in those two areas, meaning putting a bigger pile on top of what was already a huge amount that was already there. When you did that, you triggered the current regulations, and that was our contention. So that's what this letter, which is now in the record here before you all, says. And that is one little part. In other words, the fact that the federal government interpreting its own regulations is saying, in this case, with the specific facts at BCC, you have to follow the federal regulations. So we're asking the court to get us a full cleanup plan that is systematic and will not allow the waste to be in contact with the water. There's many other things that need to be done, but that's the one to wrap your mind around, because this stuff is so complex. You'd have to be, I mean, even if you're a civil engineer, unless you're Commissioner Painter, who knows a little bit about this, you wouldn't understand all this stuff. And the reason I mentioned, I think Commissioner Painter had something to do with this, but this is a national county association, and this was passed on July 24th, 2023. I think you all might know about this, but in the highlighted area down there, not written in cahoots with NOPE, because NOPE didn't know about this really, all CCR waste, regardless of when it was generated or disposed of, is managed in a manner which will prevent migration of the contaminants to groundwater and minimize the risk of catastrophic release of waste to the environment. So this is not Clermont County, but this is the association to which you belong, and it is a national statement, a pretty good policy. And then let me just quickly go to, again, the December, right up, I think this is the last, since we're just now entering March, the most recent one, there may have been one in January, but it's an EPA enforcement alert. They're now starting to enforce the law. In this alert, you can see over there on the right-hand side, closure by removal of all coal ash from these pits. That's what is preferred. but you got to still monitor the pits to be sure you got it all. It's like looking, you know, oh, well, we may remove the biggest part of the tumor, but we don't have to worry about any migration of anything, you know, any in the blood. Well, of course you do. If it were cancer, you'd know that. Well, the environment's the same. You don't just remove, although that would be a great start, which isn't happening, the biggest part of the problem, the main bucket of ash that you can easily still get to. You want to know over the decades how far this has gone, and you want to see what can be done to remediate it or stop it from going farther. And if for some reason you want to leave the ash in the pits, for some reason, which isn't preferred, you want to get all of the water out. That's why I told you about the hat in the pool. If the water is coming through in groundwater rushing from the side, and the cap is this little area, but the water is running through, you're not getting all the water out. That's why removal is probably a better option. But even now, you're not even required to get the water out. So decisions are being made. So why am I here today? Why wasn't I here years ago? And that's an excellent question, actually. Maybe I should have been, but we didn't know all this stuff. We had to find these things out a piece at a time. And quite honestly, the kind of costs that NOPE has incurred are not in the hundreds of thousands. They're beyond that. I mean, this is not easy stuff, okay? But we're familiar already because of the 1986 agreement. Decisions are being made today, right now, about leaving water in contact with the waste. The CLP is implementing plans that NOPE says in all of its pleadings are woefully short of federal law. They leave the water in contact with waste. CLP and the Ohio EPA are making decisions about, quote, closure. Again, the Ohio EPA was asked, for example, hey, do you know what the people in Clermont, the Clermont County commissioners, think about what you're doing? This is under oath in Columbus in an ERAC hearing. And the answer given is, we don't need to tell the county or ask the county for input because the OEPA feels that it knows what the county is concerned about. So we thought maybe we should come over and more fully explain this because I don't believe it's an accurate statement and that they know what you're thinking about. They didn't tell you about the decisions that are being made or explain them step by step. So what about this key information that's being withheld? Some information that we have just gotten because Judge Barrett ruled that they had to produce documents to us, which they've been withholding for a couple of years. We finally have gotten documents. Some of it is marked confidential, but we know that these documents generally magnify our concern about the uphill as well as the downhill areas. We can't show you these documents, which we'd like to give your lawyers and Mr. Bloom and his staff right now because we have to go through the process in the court about making sure that they don't look secret to us, but they right now are temporarily stamped a secret. And most importantly, if you take what the CLP president said, that he is cleaning up and he gets paid when he cleans up under Ohio EPA regulations. And I'm sure means exactly that because we know everything they've done. He is saying, true, we're not cleaning up under the federal regulations, which have to do with waste in contact with water. And the waste in contact with water is what the threat is to the environment where your people live. And and it's a strange statement. He said publicly, I don't get paid until I do this. Well, who's deciding that? Who's deciding? Well, you did it well enough. Who's deciding all these things? So we want the public to know what the agreement between Duke and CLP says. And this 2008, and I'm talking about the agreement, the 2018 liability transfer agreement, it remains top secret. Now we're going to approach Duke again. We're going to approach CLP again, and we're going to say, get rid of the secrecy. Let's tell the people what the deal is. If, you know, if any, obviously something in the, what's it, 700 pages?
It's yeah, I think it is with all the attachments.
Yeah, with the attachments, a lot of words, but at the heart of it, what's going on in that? And I think governments might be interested in wanting to know this, since it has something to do with the contamination that is still out there. And the Ohio EPA admits under oath and not under oath, both, that they don't do it readily, but that they can't enforce this law. They do not have the authority. They do not have the power. And frankly, they don't even have, I don't think, the desire to. It's just not what they do. But it is what NOPE can do and what NOPE has done in federal court, which is, I mean, hard to believe that it takes a citizen group to do this, but it does. So if they don't quickly agree to make this public, we're going to go to the court and we're going to ask Judge Barrett to do whatever needs to be done to review this and to make it, at least the parts that we would be concerned about, public. And we think the county would benefit from knowing and understanding, the county and other units of government. And so right now, the court has the motion for summary judgment, which says if the court rules NOPE's way, you're liable. The only thing we have to do now is go figure out how to clean up this mess. You're liable under this federal law, and whatever the federal law requires, you have to do. That's what the summary judgment, that's where we are, you know, and it avoids the trial on that issue if it's approved. Now, CLP is trying to do everything it can to delay consideration of that motion. So today, the county sort of is at the stage now where it needs to decide respectfully if it would benefit from the federal court determining that the federal law applies. The US EPA thinks it applies, NOPE thinks it applies, but a federal court's the one you want to really have rule on that. So would the county benefit? Second of all, if the county would benefit from a federal court's enforcement, you have to decide if the county would benefit from the federal court's enforcement of the rule. And you really have to decide if it serves the interests of the county to leave the CCR waste in contact with the water. So we're urging you, the elected leaders, to decide now, to decide how to express your concerns about secrecy, about your concerns about the enforcement of federal law. When you recognize, and after you've talked about this with your lawyers and your other administrators and staff, whether it's in your interest to do something to protect the health and property of your constituents. So thank you. I'm going to now, Wayne Harris, our chair, has a few words to add.
Okay, thank you, Dave. Well, good morning. Needless to say, I'm privileged to have your audience. Of course, I know Bonnie, and she and I've had a lot of discussions, and she's been very helpful over the years. I may be the only one in here, David, that saw your dad play basketball. He was pretty good, by the way. I was not that old, but Quite frankly, he was a good player, and I remember that. And I would be remiss if I didn't mention we have Joan Lori here, who was our treasurer, and she's one of the founding members, along with her husband, who has passed away 40 years ago. We also have Greg Lori, who is one of our new board members, and Greg is responsible for working with the township on our preserve, which is quite something. I'll just take a few minutes to give you a little frame of reference, context, if you will, about NOPE. NOPE is a 501c3, and to date has been entirely funded by the efforts of the citizens of Pierce Township. And I think you all know that Pierce Township has been tightly zoned since the 1950s. And you may not know this, the last time I looked, the average home values in Pierce Township are slightly higher than Anderson Township in Hamilton County. And that may be news to some people. But when you go back to 1984, the community discovered that the existing utility company, CG&E, had purchased hundreds of acres in the heart of the township, surrounded by people and surrounded by homes. And this property was to be used for coal ash disposal with mammoth open dumps, several stories high, and the stuff was flying all over the place. So at the time, there was absolute panic in the community. And to say that it was traumatic is an understatement, because people saw all kinds of bad things that would happen. So out of this trauma, NOPE was formed. A 2-year battle ensued. Intense and costly negotiations took place. A NOPE colleague, who you probably know, Christopher Knoop, and I were the NOPE negotiators along with the Altman Law Firm. So NOPE did prevail, and we had, I think, the better legal argument. But most importantly, we rallied the public, and public opinion was important in those days. But out of that, we did provide CG&E with a better method for disposing of the ash, and it was called Valley Fill. And so it was essentially a win-win for everybody. Most importantly, and I think Dave mentioned this, there was a binding agreement struck that protected the community and gave NOPE important rights and a say in the future. And this agreement had numerous elements to it, but there were 3 very important parts to the agreement. First, NOPE received rights to information and methods for coal ash disposal and its potential impacts. And there were procedures for follow through and follow up. Second, the hundreds of acres that CG&E purchased for coal ash disposal would become land used for the community to enjoy, which has happened. It is now a beautiful natural preserve with 3.5 miles of walking trails. And third, neighbors adjacent to the existing ash pits would have greenbelt buffers, and NOPE would hold the easements to those buffers. And so 40 years later, after a sequence of different owners, NOPE finds itself in another legal battle with the current owner of record, CLP, and the entity of record responsible for environmental impacts regarding the Beckjord property. And even though CLP purchased the property, they were paid a lot of money, hundreds of millions of dollars, to take on the responsibility. So we didn't ask for this challenge. I didn't ask to be chairman, but like you folks, when you're asked to serve, you serve. However, when you know there's real potential for bad things to happen, such as the potential for rupturing of the walls of these massive ponds with billions of pounds of toxic ash in it, and when you know that open air dumping violates federal regulations, and once you know there could also be a potential violation of the water system, the water wells, once you know these things, you got no choice but to stand up for what's right. And understand this, NOPE's charter is about preservation and protecting the community's air, soil, and water. NOPA is not about restricting the amount of water for your toilet to flush, or we're not forcing you to buy an electric car. That's not who we are. It's solely about the community, the air, the soil, and the water, and protecting the character of the township. And finally, this is very important. NOPA is one of the very few organizations in the entire country that has legal rights and has standing in the courts to ensure that community rights are protected. And I would simply close my comments with this. NOPA has been fortunate to have some very talented and dedicated citizens on his board and as members, both 40 years ago and now. And we've had the luxury, and I want Dave to blush, but of having legal representation from one of the foremost environmental law firms in the country. But today, we ask for the support of our political leadership to ensure that the right things are done here as we pursue this through the court system. Thank you.
Thank you. Any other comments?
Only if there are any questions.
Just to talk about that situation, for a second, since I'm kind of familiar with that, and I know my fellow commissioners are too. They're up to speed on what's going on at Beck Jordan, what has went on there. Many years ago, environmental companies, the federal government, entities thought that the way to handle waste was to put it in the ground. If you put it in the ground and you cover it up and you put some clay on top of it, that'll shed some of the water off of it. That'll keep water from traveling through the material that you've covered. And no one ever thought about groundwater impact. They didn't. In Beck George's particular case, even though that complied with the NOPA agreement, this material contains hazardous materials and heavy metals. And so it was inevitably that it was going to travel to groundwater. I think Lyle Bloom is here that works for our Water Resources Department. We know that. We have seen that material contact groundwater since 2012. I believe that's the right date. Is it before that? Mid-90s. Mid-90s, and that the migration started into one of the wells within the Clermont County well field. And the mitigation method for that was extraction well. Currently, that extraction well is still operating down there and under a permit to dispose of that water directly into the Ohio River. That particular extraction well is pulling a negative on the groundwater just far enough, which isn't much, to keep it from migrating into the well field. And one of the things that Clermont County insisted on was a second extraction well, because knowing that mechanical means will fail and that one of those has to stay in operation 24/7. And so we know that. We federal and Ohio EPA knows that material that has been deposited at Beck Jordan is in contact with groundwater and continues to contaminate groundwater. And there is really the nemesis of the federal law that says you can't leave this material in contact with groundwater. Eventually what will happen, over a period of many years is that an additional well will be impacted. One well has already been shut down and we don't draw water from it. And then eventually the good people of Clermont County will be on the hook for whatever means has to be employed to remove these hazardous materials from groundwater if you want to continue to use that groundwater where it's extracted near and close to the Ohio River from the aquifer. I mean, that's where it is. So even though, and just to talk about that, a properly constructed landfill is 5-ply geotextile in the bottom with a leachate collection system. And then the material is systematically put into the landfill with, again, a 5-ply geotextile liner. And that particular unit is engineered for 200 years. That's what the engineering capabilities of that are. Now, I won't argue that may be a euphemism for 200 years, but, we'll talk about that. That is how it's done in the industry. The only acceptable thing that can be done with that particular waste material is for it to be exhumed and then moved into an area that is prepped just exactly for that kind of disposal in a dry area way above the groundwater location and away from that site and away from the Ohio River. And so that's where Clermont County needs to move. Not to do so will result in eventually a treatment system having to be installed that today we believe is somewhere around the $30 million number that the good citizens of Clermont County should never have to encounter and or pay for because of a legacy waste that was left all the way back from Cincinnati Gas and Electric through Duke Energy and now through CLP and New Richmond Corporation. I mean, that's where we're at. And to do anything less will be a travesty on the far end. The only difference in this and Fernald, Ohio, that made a difference is that Fresh made an appearance at the United States Congress and that they lobbied for this on the congressional floor. And finally, when that information was made available, then and only then did the US EPA step in and actually declare Fernald a surplus site. You know, and eventually my fear is that that's what will have to happen here. You know, absolutely, David.
Well, first, thank you for the commissioner's understanding of something that most counties don't yet understand and extremely important. The one thing that I want to be clear about is because of NOPE's efforts, and you are now in a unique place. Do you know how many remaining enforcement suits there are in the United States raising this issue? One. Here. You can help today your citizens who created that situation and have spent the resources. That's why we're here today. But everything Commissioner Painter has said is, of course, accurate. This is pivotal. And remember, it's not, while I represent water companies that have other problems that are unique and gigantic. I understand how important drinking water is. But walking your dog, letting your puppy lick something in a stream, watching your kids play in a stream, all of this is impacted by the kind of content, and it's not even being monitored as it would have to be under the federal law. So that's why we're here today. And you have a unique in the United States pending case. There was one other one, and it's temporarily not going forward. Temporarily. You have the only one. Unique opportunity. So thank you very, very much for your attention and all the time you've given us.
You bet. Thanks for being here today. We will move on to the agenda. The next item is E, public participation. And is there anyone here that wants to speak from the public? Absolutely. You can do that. You are welcome to do that. Prior to that, let me just let you know, during this time, the board does not answer questions or engage in debate. No member of the public may comment about a matter that is not within the preview of the Clermont County Commissioner's responsibilities. The commissioners are not expected to comment on matters brought to the board during this time. Each speaker will be recognized by the board president for speaking. And in accordance with the board's rules, your comments will be limited to 5 minutes. Please state your name and your address.
Yeah, my name is Nick Bundren. I'm here on behalf of a nonprofit called the Ohio Land and Liberty Coalition. What our mission is to speak on the ground with county commissioners, township trustees all over the state of Ohio about solar and renewable energy. Our group consists of farmers, landowners, and stakeholders who are more conservative in their political leanings, but support utility scale solar and wind on the basis that property rights need to be upheld. And the reason I'm here this morning is because Clermont County is also in a unique situation with solar and wind, as you are one of just a handful of counties that have recently had projects come online and be operational. And so I just wanted to introduce my group, and hopefully I was going to try to ask some questions about some of the issues that y'all have had in the community, particularly with public outcry, land use questions. But if that's not the right format for this, I can definitely leave y'all my email and maybe get some questions answered online. But don't want to waste any more time just introducing myself. Thank you.
Do you have an email address with you that you can give to the clerk?
Totally left my cards back.
Do you know? Just give it to her. I do that all the time myself.
Well, thank you for your time.
Thank you for coming in.
Thank you.
I'm going to leave my phone number as well.
Okay, thank you.
Thank you.
Thank you.
Thank you.
Thanks for being here. Anyone else from the public? Seeing none, we will close public participation and move off to F, the consent agenda. Board, you've had the consent agenda early, the opportunity to review it. Are there any items that need to be pulled off for further consideration? Hearing none, and ask for a motion to approve the consent agenda as provided.
I'll make the motion.
I'll second.
It's been moved and second. Any further conversation? Roll call, Rebecca.
Commissioner Corcoran,
Yes.
Commissioner Batchelor,
Yes.
Commissioner Painter.
Yes. We'll move on to the non-consent agenda. Non-consent starts on page 4 with item number 7. Hello there, Dr. Watson.
Good morning. Hi, Leanne Watson from the Clermont County Mental Health and Recovery Board. Thanks for your time today. I'm here regarding resolution number 7. So the Clermont County Mental Health and Recovery Board resolution reducing the size of the Clermont County Mental Health and Recovery Board of Directors from a total of 14 members to a total of 12 members in accordance with Ohio Revised Code Section 340.02. So in October of 2023, there was a change in 340, which is the code that regulates the mental health and recovery boards. And it gave the commissioners the ability to change the size of our board of directors. So there's a choice between 18, 15, 14, 12, and 9. So in January, Commissioner Corcoran came to our board of directors meeting to talk to our board of directors about the ideas to change what their thoughts were about the size of our board. And we would like to recommend that we drop from 14 to 12.
Okay. Thank you. Board, you've heard the reading of item number 7 to make this change to the Mental Health and Recovery Board members. Do I have a motion for approval?
I'll make the motion.
I'll second with clarification. It's resolution 015-24 for the record.
Correct. Leanne called it 7 because it's item number 7.
Yeah.
That's
Sorry.
That's all right.
Still new to this.
I just made sure it didn't get, no, we can't do that. We got to come back again. Yeah.
We understood. Any further conversation or discussion? Roll call, Rebecca.
Commissioner Batchelor,
Yes.
Commissioner Corcoran.
Yes.
Commissioner Painter.
Yes. Thank you, Leanne.
Thank you very much.
Your board too.
Item number 8. Morning.
Item number 8 is a recommendation to execute the third amendment to the professional services contract between the Board of Commissioners of Clermont County, Ohio and Axon Enterprises Incorporated, 1700 North 85th Street, Scottsdale, Arizona, 85255. A sole source provider for the provision of one additional law enforcement body-worn camera seat license for a total increase of $5,087.46 for the period of February 2024 through February 2027 in compliance with section 307.86 B1 B2 of the Ohio Revised Code with all terms and conditions of the agreement to remain in full force and contingent upon the release of the required purchase order. And the total amount breaks down as an increase of $726.46 as of February 2024, $1,397.04 as of August of 2024, $1,452.92 as of August of 2025, and $1,511.04 as of August of 2026.
Thank you. Board, you've heard the reading of item number 8. Do I have a motion?
I'll make the motion.
I'll second.
It's been moved and second. Any further conversation or discussion? Roll call, Rebecca.
Commissioner Corcoran.
Yes.
Commissioner Batchelor.
Yes.
Commissioner Painter.
Yes. Thank you, sir. Item number 9. Morning, Suki.
Item number 9 is a recommendation to accept and execute the annual county highway system mileage certification. This is for Clermont County for calendar year 2013. We're certifying the total eligible number of miles for the county to be 383.479. This is as of December 31st, 2023, pursuant to Section 450104 of the Ohio Revised Code. So this is actually a reduction of 3.6 miles due to now calculating the mileage based on LBRS. ODOT's doing it that way now.
Board, you've heard the reading of item number 9. Do I have a motion for approval?
I'll make the motion.
I'll second.
It's been moved and second. Any further conversation or question? Roll call, Rebecca.
Commissioner Batchelor.
Yes.
Commissioner Corcoran.
Yes.
Commissioner Painter.
Yes. Item number 10.
Item 10 is a recommendation to accept the 2023 summary report of force account projects that was submitted by the engineer's office. This will show what was done last year under the resolution that the board approved in January, resolution 00223. And this is in compliance with section 554319. So what you had been presented is a list of all of the force account projects that we did force account estimates for last year. So there was about 61 of them that were bridge and culvert related. It amounted to the total of all the estimate was about $1.1 million.
Okay. Thank you. Board, you've heard the reading of item number 10. Do I have a motion for approval?
Make the motion.
I'll second.
Then moved and second. Any conversation or questions? Roll call, Rebecca.
Commissioner Corcoran.
Yes.
Commissioner Batchelor.
Yes.
Commissioner Painter.
Yes. Thank you. Item number 11.
This is a recommendation to appoint the following representatives to serve on the Child Abuse and Child Neglect Regional Prevention Council for the terms outlined below for the purpose of administering child abuse and child neglect prevention programming and services in the Southwest Ohio region in compliance with Section 3109.172C1 of the Ohio Revised Code. That is Arlie Harmons for a term of February 29, 2024 through February 28, 2026, and Amy Burke for the same term.
Board, you've heard the reading of item number 11. Do I have a motion for approval?
I'll make the motion.
Second.
It's been moved and second. Any further conversation or discussion? Roll call, Rebecca.
Commissioner Batchelor.
Yes.
Commissioner Corcoran.
Yes.
Commissioner Painter.
Yes. That concludes our non-consent agenda. We'll move to item H. Do we have any additions to the agenda today?
We do not have any additions at this time.
Okay. Then we will move to item I, requesting an executive session in accordance with section 121.22 G1 and 121.22 G4 of the Ohio Revised Code to first consider the employment, dismissal, or compensation of a public employee or more public employees, and second, in preparing for conducting or reviewing negotiations or bargaining sessions with public employees concerning their compensation or other terms and conditions of their employment. Board, do I have a motion to go into executive session?
Make the motion.
I'll
been-
second.
Been moved and second. Roll call, Rebecca.
Commissioner Corcoran.
Yes.
Commissioner Batchelor.
Yes.
Commissioner Painter.
Yes, we will move to executive session. We will return and conduct further business. Thank you. We've returned from executive session. No decisions were made and no actions taken. Just to go over why we were in executive session was under section 121.22 G1 and 121.22 G4 of the Ohio Revised Code. To first consider the employment and dismissal and compensation of a public employee or more public employees, and to prepare for conducting and reviewing negotiations and bargaining sessions with public employees concerning their compensation terms or conditions of their employment. We'll move on with the agenda. Tom, are there any additions to the agenda before we move on?
We do have a personnel action.
Okay.
For consideration, so I'll let Sandy read that after we add it.
All right. Board, can I get a motion to add a personnel action to the current agenda?
Go ahead.
I'll second.
You move.
I guess.
It's been moved and second. Roll call, Rebecca.
Commissioner Batchelor?
Yes.
Commissioner Corcoran?
Yes.
Commissioner Painter?
Yes, we've added the item. Sandy, you're here to discuss it?
Yes, I have a personnel action for the Facilities Maintenance Department. Wade Grabowski, Facilities Management Director, administrative leave, non-discipline with pay, effective February 26, 2024.
Board, you've heard the explanation of the personnel directive that needs to be considered today for admin leave for non-disciplinary pay for Wade Grabowski. Do I have a motion to approve that?
I'll make the motion.
I'll second.
It's been moved and second. Any further conversation or discussion?
No.
Roll call, Rebecca.
Commissioner Corcoran?
Yes.
Commissioner Batchelor?
Yes.
Commissioner Painter?
Yes. Thanks, Sandy. We'll move on with the agenda. Item J, any county staff elected official discussion? None. And item K, member comments. Board, any member comments?
No, not at this time. Thank you.
Okay. Then we have ended up at item L, which is a request to adjourn. Do I have a motion to adjourn the meeting today?
So moved.
I'll second.
It's been moved and it's been second. Any further conversation or discussion before we call this meeting?
No.
Rebecca?
Commissioner Batchelor?
Yes.
Commissioner Corcoran?
Yes.
Commissioner Painter?
Yes. Our meeting for February 26th is hereby adjourned. Thank you for joining us today, and we will see you this coming Wednesday. Thank you.